rise. The Court of Appeals Division 1 is now in session.
Please be seated. Well, good morning. We are here for oral argument in case number CV18-0151, AHS Rescue versus Arizona Outdoor, AZ Outdoor. Counsel, each side has 20 minutes for your argument. The appellant may reserve a portion of that time for rebuttal. We would just ask you that you keep track of that yourself with the clock on the podium. These proceedings are being audio and video recorded, so we would be grateful if you would identify yourself and your client when you approach the podium. We have read the briefs, discussed the case at conference this morning, and are familiar with the arguments raised. So please keep that in mind when you're making your arguments. With that, you may proceed. Counsel.
Good morning, Your Honors. May it please the Court, I am Guy Roll, and I represent the appellants in this matter. They include AHS Rescue, Irene and Dale Stewart, who are present in the court behind me. It is my intention to reserve 10 minutes for rebuttal, but we will see how questioning goes. In brief background in this matter, it started in February of 2011. The parties, my clients, the Stewarts, through their company, AHS Rescue, approached the defendants in this matter, Arizona Outdoor Specialists, referred to as AOS in the pleadings, and they're in the principles of AOS, Misters Heald and Ford. My clients approached them about an opportunity to do a joint venture of a river rafting company. It kind of seemed to be a blend of the two companies. This was pursued as a partnership. Both sides agreed, and it is undisputed that it was intended to be a 50-50 partnership. Both the Stewarts stated that, as well as both Misters Heald and Ford agreed that it was a 50-50 partnership. And in fact, the documents that the parties signed stated just that, both the shareholders agreement as well as the bylaws of the corporation that they formed. The corporation that they formed together was Cliff Creek Operators, CCO, referred to as CCO. And in less than approximately 5 months later, the defendants in this matter started looking elsewhere for another transaction. Without the plaintiff's approval or knowledge, the defendants entered into a purchase agreement with another rafting company called Cimarron. And rather than using their own assets through AOS, they did this transaction through CCO. And at the time, at the formation, the two shareholders of CCO were the two respective companies, AHS Rescue and AOS. The directors were the four principals, the Stewarts and then Misters Heald and Ford. However, the officers of CCNO were just the defendants. My clients, the appellants in this matter, did not serve as officers of CCNO. This was pursued in direct violation of the shareholders agreement and the bylaws. I think it clearly states in the shareholders agreement that it requires the consent of all the shareholders in pursuing any transaction that involved additional shares or acquiring, issuing of additional shares. That is the same in the bylaws in section 3.12, where it gives a list of different actions that require, and it states 100% written affirmative vote or written consent of 100% of the directors.
Counsel, let me jump to the two forms of judgment, sort of the end of the story. Did you object to either of those proposed forms of judgment in the Superior Court?
The two forms of judgment, the Superior Court, no.
Is that significant?
In this matter, I don't believe, no. I think the two significant issues that we're addressing are the trial court, whether it erred in relying on the business judgment rule in reaching its ruling, which it certainly did. In the outline of my argument, what I was coming to is that there was no basis for the actions that were taken. There was no authority, there was no authorization for the defendants.
Counsel, sorry for interrupting, but assuming there's a breach of some kind, what was the remedy that your clients were seeking in the Superior Court?
There were several remedies. First, in the breach, my clients lost parity of their stocks, of their shares in the company. They went from a 50-50 partnership.
Okay, but assuming there's a breach, so what's the remedy for that, for losing that 50-50 share? A monetary remedy is my question, I guess. Was it a monetary, or were they seeking something else?
A declaratory remedy that would establish them, that put them back into their 50% position. When subsequent to the transaction with Cimarron, they went from, and without their knowledge or consent, they went from a 50%, a full partner, to a minority shareholder of roughly 43%.
So the oral argument transcripts seem to suggest that the only remedy they were seeking at that point, they were saying we want monetary damages.
They also want.
But am I reading that wrong? Did they also preserve some type of claim for something other than monetary damages?
Well, they clearly wanted to be restored to a 50%.
But what did they suggest that would look like? How would they be restored to that?
That the shares, it was the defendant, AHS, that decided to use not only a portion of its shares, but a portion of AHS Rescue shares in admitting and bringing in this new entity.
Weren't they new shares that were issued?
There were new shares that were issued.
Right.
Which again is in violation of the bylaws.
And here's how I see the case coming to us, and I understand your position on breach. But one way to look at the appeal is it comes after the Superior Court found that damages weren't adequately disclosed, shown at the summary judgment stage. I don't know if you agree with that assessment of how the case comes to us, but that, to follow up on Judge Catani's question, implicates what claims remained at the time of summary judgment, and then what disclosures, 56 motion practice occurred with respect to those claims. And the brief suggests, at least, or the answering brief suggests, that the non-monetary claims had been resolved by that time. And I think that was counts 9, 10, and 11. If I recall correctly. Were those still viable? Were those still in play at the time of the summary judgment?
I think the confusion, they were resolved as to Mr. Colby. He was, after the initial complaint was filed, there was a motion for summary judgment where it was ordered to bring Mr. Colby into, and the only claims against Mr. Colby were those 9, 10, and 11. It was the plaintiff's position that Mr. Colby was not, in fact, at no time was he, at the signing of the shareholders' agreement, he was never in privy to contract with them at that time.
Let me ask you then, because the minute entry, at least as to count 9, suggests that count was dismissed as to all defendants. Count 10, I think the court found that declaratory judgment was superfluous and wasn't proper under the Deck Judgment Act. And then I think later there was a filing that appellants made withdrawing count 11. So help me understand why those didn't resolve, why those actions, either I'm misreading them or those didn't resolve those claims.
The count 10 was superfluous as a claim. The discussion was it was a remedy that was being sought. For the declaratory, that was the relief was being sought was to have the plaintiffs, or the relief would be to have the claimants receive the shares that were wrongfully, or And let me back up. Not that the shares that were taken from, because you correctly stated that there were new shares that were issued, but their position of parity to have that resort. So it's the plaintiff's position that in deciding not to initially pursue Colby or the other principals of Cimarron, that they would let that transaction stand, but what they wanted was parity to come back to their partnership, their 50% partnership that they had agreed to and signed under the shareholders agreement and under the bylaws. Then, in addition,
But I read the argument as your client seeking to be compensated for no longer having a veto power, if you will, a 50% interest. Am I misreading that? Was there a suggestion that there was a different remedy? If the remedy was a monetary remedy, there seems to be a way to put a value on a less than 50% share. Was that what they were seeking? Monetary damages for having lost their 50% share?
the monetary damages that they were seeking were as a result of the actions taken by the officers of CCNO that deprive them of their profits in the company. I think this was outlined and presented as a exhibit to the response to the motion for summary judgment. In it, the profit and loss statements clearly outline there are several categories that require, again, under the documents, under the shareholders agreement and the bylaws, required the knowledge and approval of 100% of the directors.
So
that was never attained.
Your client was seeking lost profits, is that correct?
It was not, when I say lost profits, it was seeking the damages that it suffered that were paid, that essentially AOS, the defendants, paid to itself through the company CCO. So AOS effectively controlled the company. They told the plaintiffs, you're out of luck, you're not getting anything, and we're going to, and they dressed it, they couched it in terms of reimbursing expenses as management decisions. They paid themselves close to $800,000 of revenue out of the company. So that is and all of that was done clearly in breach of the shareholders agreement and the bylaws. And then later their justification for it was, hey, these are management decisions, and under the business judgment rule, the court has no authority to weigh in on our management decisions.
So, and are those I guess, the fee argument that they were paying themselves a management fee?
Not just a management fee. They were paying themselves, in addition to a management fee, they were paying salaries for their own employees. They were paying various rents. They were paying additional salaries that were never approved. Okay,
so let's pivot to Arizona Rule of Civil Procedure 26.17. Where, or I guess in what disclosure statement, do you provide a computation and measure, those are the words, of damages?
In the third...
Of those damages that you're just talking about, the pecuniary...
Correct. And it was in the third supplemental disclosure statement, and what was included were the transcript of the deposition of the defendant's expert, and inclusive was an outline of the profit and loss statement that he had presented.
The defendant's expert set forth some damage amount that your client was seeking?
He outlined in his, this was Exhibit G to the response to the motion for summary judgment. It is I guess a profit and loss summary that included December 2010 through November of 2016, in which he summarized and put down profit and losses of the corporation.
And those were the damages your client saw?
And these were, yes, they outlined there were 5 specific, I believe around 5 line items within there that during the deposition there was never, they were never approved, and they fell under the bylaws, and in this case they specifically fell under the bylaws, the section I want to say 3.12, where they required, those expenses required the approval of 100% of the
But your
board.
claim for damages, though, let's say it was some sort of expense that benefited the company. Presumably, you wouldn't be claiming the total amount as damages. What was the amount that was disclosed is saying we were damaged in this amount? You're saying just the total amount that was spent, even if some of the amount that was spent resulted in some type of benefit to the company?
That would be for, and I guess that's begins to be a factual question for a jury to decide, is my clients have a claim for monies that were spent without authorization, monies that were and they were spent by the officers to their own company. So our position is that the defendants were basically raiding CCO and making the joint company nonprofit.
Did you allege that every penny that was spent, that nothing benefited the company?
No, that was never alleged. That is not, and we would agree that is not the case. That not every
I'm
penny.
still not clear as to what amount of damages you would be seeking based on the defense experts' statement, or just the overall profits and losses, or the overall amounts that have been spent.
And that was a figure, there was a figure of roughly $900,000 that was in the disclosure statement that the defendants Pelley's brought up, and that was reached
Was that after discovery closed, the third supplemental disclosure statement?
and that was issued the same day of the deposition of the expert.
Okay, so the 900,000, I was under the impression, was disclosed after discovery had closed. Is that not accurate?
It was not in the form that it was given to us. It was disclosed the day that we deposed their accounting
Well,
expert.
let's talk about the form you disclosed your damage figure. So if we look to the third supplemental disclosure statement, does that say, and I don't have it in front of me, my client was damaged in the amount of X, and this is how I've computed it? Or does it just attach two documents that you're explaining today could have informed that question?
And it states, in part, as a result of the defendant's breach of their agreements with the plaintiffs and in breach of fiduciary duties, defendants were unjustly enriched, and plaintiffs are entitled to recover payments that the defendants wrongfully made from CCO to either AOS or parties known by defendants in the form of operation management fees, non-tour payroll allocations, rent, lost revenue, and expected revenues from shutting down plaintiffs' operations related to CCO as well as others. Plaintiffs expect to prove at trial that such resulting damages are in excess of $900,000. And the basis of those were from the profit and loss statements of the corporation that were finally presented or disclosed by defendants through their expert, which is significant. Differed from prior disclosures of the profit and loss statements. So from those figures, and as I recall, I think at the deposition there were amounts that were previously not known that had been expenses of the corporation that had not been disclosed. And again, my clients were not officers. It was the appellees and the defendants in this case that were the officers. And as I say, I have a minute, just above a minute remaining if there.
Thank you. Mr. Lavelle?
My name is Mick Lavelle. I represent Arizona Outdoor Specialists and Heald and Ford. I'd like to reserve 2 minutes for Mr. Colby and Cimarron's counsel at the end of this, but since the brunt of the brief seems to be headed my way, gave me the responsibility to talk to you. Just so we're clear, this is what Mr. Roll said when we were talking about what his remedies were in court. Talking about the transaction, we're not looking to have it void. We're not looking to undo the transaction. We are saying that CCO, fine. The relief we're seeking, as in many contract cases, the relief that is being sought are monetary damages. A little later on, plaintiffs seek ultimately are, monetary damages to be proved at trial. That's not very surprising because he also said we don't want to undo the transaction. And on the basis of that, the judge, you will see in the minute entry, says some of these things have gone away.
That was in motion practice involving Mr. Colby, wasn't it? That was
That's
September.
Right. And obviously he had a motive for saying that, because he was trying to argue that Mr. Colby didn't need to be there. The court determined that he did need to be there.
What are we to make of that, though? What are we to make of that, though, given that the appellees here are not Mr. Colby?
Well, I think you make of it that, number one, the only viable remedy in light of that is damages, whether he conceded to it or not. There is not a claim in his disclosure or any place else that he is going to undo this transaction. And I can't even creatively imagine any other remedy that they would seek that wouldn't be economic damages of some kind or another. I want to make a point about these disclosures. There have been kind of an amazing disregard of the requirements. The third disclosure, as all of his disclosures, are not verified as required under Rule 21.1G, I think it is. The complaint is not verified, and his entire opposition to the motion for summary judgment, when you get into the record, is based on pieces of paper. No testimony, nothing there. But even if you assume, okay, we're going to look at this unverified statement, which is obviously something a lawyer has written someplace, under the mandates of Gilmore and Rancho Pescado and the many other cases, in the briefs I want to address this. There is a distinction between were you damaged and how much was there, and I'm not trying to blur that distinction. Rancho Pescado says, recognizing that breach, however, there must be a reasonable basis in evidence for the trier of facts to fix computation when a dollar loss is claimed. The burden, this is Gilmore, the burden on the plaintiffs is to show the amount of damages with reasonable certainty.
And I would agree. If there's certainly a way to show I used to have a 50% interest in a company, now I have a minority interest. If I were to sell that, I would have someone come in and put a valuation that's probably less than it would have been if I were selling a 50% interest in this company. So you can do that for monetary damages. But I understood the argument in opposition to their, at least one of the arguments was you haven't proven any damages, period. And aren't you just damaged by virtue of no longer having a 50%? I mean, can't that be remedied by doing something to give the plaintiff veto power, or to put them back in a position of that they were in as a 50-50 partner?
you could have, but not without affecting Mr. Colby. Where does he go with the shares he purchased? And
So
you
you're saying he would necessarily have to unwind that transaction.
and he disavowed any intent to unwind that transaction, and there's no document anywhere that suggests that that's part of his case. This is something that just popped up in the briefing process.
Couldn't he ask your client to make up that margin and not ask Colby to?
No, and in fact, I want to dissuade the court from thinking we didn't have a side to all this. At the meeting where we contend that it was agreed to, and it doesn't require signed writing, a meeting can be good enough. He says he didn't know what happened. He doesn't recall.
Who's he?
Mr. Stewart says when I questioned him about that meeting, he says, I don't recall. He did not come forward and say
That
this
meeting,
didn't happen.
meaning the sale of additional
The sale of additional shares. Secondly, when Mr. Colby and Cimarron came in, obviously they brought value. There were two other people that involved in Cimarron that each got $25,000, and they're not trying to get their money back. There were permits on the Verde River that we wanted to have. Now, I'm not suggesting that that's determinative, but it's perfectly obvious that anybody that's going to say you shouldn't have spent that money, you didn't have authority to spend that money, is going to have to do some sort of damages calculation to say, well, you got this much in value, or I contend the value is only this much, and therefore that much got spent over and above that value, and my share of that much, I guess derivatively is what he's looking at, is X. None of that ever happened.
So your colleague wouldn't say, make us 50 again. He would say, bring us to 50 and discount that 50 by whatever value this transaction brought into our arrangement.
That's what I think would happen at a trial. They did not say a thing. They sued us with this generalized language and then avowed that all they were seeking was damages, didn't sue the other people. The transaction was $25,000 to one person, $25,000 to another person, and 25,000 shares to Mr. Colby. They didn't sue Colby or any of those people to start with.
Well, not how you think the trial would have gone. Is there a requirement under the law that, let's assume they were moving for that percentage adjustment, bring us back to 50, that they have to account for value that the transaction brought to the corporation with a discount?
I would certainly think so. Otherwise, they'd have a windfall. Secondly, if these are really derivative claims, they have a responsibility to set out their calculations and present it to the court, to the board of directors and all that sort of thing. He just went dark and refused to sign the minutes of the meeting and then brought this lawsuit. There wasn't ever a time when he indicated the kinds of things you're asking about. None of that ever popped up here. Finally,
Counsel, before you get at that final point, let me ask you, Gilmore was decided in the 60s, long before 26.1 was promulgated. 26.1's been rattling about for a little over a generation now. What's the strongest published case supporting your position in this case?
Rancho Pescado, aside from the lost profits language that is in it. Rancho Pescado specifically goes into the difference between proving some sort of fact of damage and proving an amount of damage. And it still says there has to be a calculation of some kind. And it is not sufficient to submit, they don't say this, but I would submit that it is not sufficient to submit a $900,000 number without any calculation. I want to talk about that for just a second, too. discovery closed. We filed our motion for summary judgment, and lo and behold, 10 days before he files his response, we get this unverified magic third disclosure when we don't have any way to have any discovery or anything. I would have more of a concern about that if it had in fact disclosed some new method of calculations that gave me some basis to try and figure out where it was going. Finally, I want to hypothesize a little bit with you about whether or not it is appropriate for somebody to just say $900,000 in the face of a prior $400,000 number in the deposition and not give anybody any detail. It leaves the defendant unable to prepare a specific defense. And actually, if the judge then does what he ought to do and restricts them to just testimony about the amount but not all of the mechanizations that went into it, you got a beauty contest. The prettiest plaintiff or the prettiest defendant carries great sway with the jury in the absence of any facts for them to consider. There wasn't anything left of his case except damages. They failed to establish any methodology by which damages should be calculated. The United Bank of California case is a case that says an owner can estimate not damages, he can estimate the value of property.
Let me ask you, was it a staggered expert disclosure deadline? Meaning the plaintiff has a date and then there's a, is that how it went?
No, there was no specific disclosure provisions for expert that I recall. I haven't looked at the record to be absolutely sure of that, but.
And so when you retain your expert and you're giving them whatever information they need to rebut what I don't know, but my question is, did that $900,000 number, had that been produced in the third supplemental before you asked your expert to weigh in?
No, it had not, and in fact, the defendant, the plaintiff, had provided us with areas of expert testimony, and we were expecting a designation of an expert, and we were going to depose him. That designation never occurred. And so we had areas of expert testimony. We didn't have any substance. We didn't have a report. We didn't have the third disclosure until probably 20 days or so after we filed our motion for summary judgment, and probably 2 months after all discovery was closed. Unless there's more, I'm going to leave it to counsel for Colby.
Thank you, counsel.
Good morning. May it please the court. My name is Veronica Manolio, and I represent John Colby in this matter, who, as we understand from the pleadings now, is sort of a peripheral person on appeal. I understand from the pleadings that the appellants have all but conceded Mr. Colby shouldn't be here. I don't know why we're here, other than we've now incurred a significant amount of expense for Mr. Colby when the concession is he doesn't need to be a party on appeal. But I want to clarify a few things while I'm here, because the issues do go to my client. I want to clarify a few things about the record. One of the reasons there was never a damage calculation by the appellants, plaintiffs below, is this. Had they actually hired an expert who did a calculation, their 43% interest yielded them much more money than their 50% interest did before Cimarron. Why? Because Cimarron and Mr. Colby brought significant value. And our expert disclosures, which were timely submitted, and I will tell you, to answer the question that was just asked of Mr. Lavelle, it was a staggered disclosure date. The way that it went was that there was a simultaneous disclosure of areas of expert testimony, which both parties did, and then they were to submit their disclosures first, being the plaintiffs. They didn't do so. How do you know that? In my disclosure statement, that was the defense, I specifically included, because they didn't disclose an expert, I am giving a first expert opinion, and I'm reserving a right to rebut if you try to do something after your deadline, because you've already missed it. It's in the disclosure statement. It's in the record. It was attached to my motion for summary judgment. They didn't do their initial disclosure. They didn't rebut our expert, and they never, ever had any fact witness who could testify about what our expert opined. So what did the defense expert opine? That the company had more value, having brought on Cimarron, and that they couldn't have had any damages to quantify because they'd have to look at how much money would we have made, and they didn't know how to quantify that. They couldn't even tell you what the profitability was of their own business, much less how much better CCO should have done into the future. That's what led me to filing a motion for summary judgment. I filed a motion for summary judgment on behalf of Colby, and I believe both Mr. Lavelle and I joined each other's motions because the issue was the same. You haven't disclosed anyone to rebut the fact that your clients are actually going to make out more money than they otherwise would have. It was 45 days after disclosure was due that Mr. Roll came up with the $900,000 number, and no way for us to understand what that tied to. If you look at the disclosure statement, and I know he's attached it, it did not have any computation in it. It didn't say, I'm looking at the profitability, because again, if you looked at the profitability, his clients were financially better off because Cimarron was purchased. The other issues I just want to address for the court's sake, because they were questions you asked, counts 9, 10, and 11 were absolutely resolved before summary judgment. How do we know that? Look at Exhibit A to his own statement of facts. The judge said count 10, which was declaratory relief, is superfluous. That came after the oral argument where Mr. Roll must have said 7 times, we're only seeking monetary damages. So when you ask questions like, well, couldn't they have given back a percentage? Couldn't they have made him whole? Yes, all of the things could have been possible had they pled it and actually presented it. But when the judge said, I think a deck action is superfluous, he said, I agree. The judge dismissed it. The judge expressly dismissed count 9 as to all parties. It says it in Exhibit A. And then he, Mr. Roll, withdrew count 11. It's in the record at number 95. If we have a discussion now about counts 9, 10, and 11 being revived, that allows a party to say one thing in the trial court and then have buyer's remorse after they've lost. The bottom line here is, as to Defendant Colby, we all agree that the dismissal and the judgment are appropriate. We know Mr. Roll did not object to either form of judgment. He certainly didn't object to the final form of judgment. And because Mr. Colby's been dragged through this, he should not only be entitled to have his judgment upheld, but he should be entitled to attorney's fees in this court for having been brought here as well. Thank you.
Thank you, counsel.
If I may, there's a number of issues I'd like to sprint through. The first one going to the profitability. The profit and loss statement provided through their expert clearly shows that the business was running at a loss. In fact, the best year it had was the first year that was prior to the acquisition of Cimarron.
Who did you disclose as a witness to tell that story?
These are just basic statements that either the plaintiffs could testify to these statements, as well as the officers of the corporation itself, of CCO.
To the financial documents of this this acquired company. Could talk to the...
No. These don't go to the acquired company. These go to CCO. These go to the joint company. These were only disclosed finally through their expert. So the profits of the company, it only showed a profit after the lawsuit had been filed against them. So that clearly refutes the statement that was made about profits. Also, there was a statement made. There was in no way, shape, or form did the plaintiffs ever agree to the acquisition or to giving up their parity, their 50% share. They were adamant about having 50% control from the start. They would have never entered into an agreement, into a partnership where they did had a minority share. In fact, what happened is Mr. Colby is an employee of AOS, effectively giving them a majority control of the business. So they took over the business. They bled it. I mean, the profit and loss, when it shows losses, if it was such a valuable acquisition, it continued to show losses after the acquisition. Not looking to undo the transaction, that is correct. We stand on the contract, and at that point, as pointed out, you had to bring in Mr. Colby, then you would have to bring in the other individuals who were long gone. So we accepted that we're not going to undo the birth of the baby. It exists. What we wanted to get back, our remedy was to get back to parity. It was superfluous to have that as a claim, and we were looking to do it as a remedy. And the third disclosure was done the same day as their expert's deposition. He provided the documents, the profit and loss statements that had previously not been provided or disclosed to us. So it was not done. And
Counsel, I would ask you to wind up since your time.
Sorry. And Mr. Colby had filed his motion for summary judgment prior to the deadline. This disclosure was done prior to the AOS defendants filing their motion for summary judgment, not after. So just disputing or correcting as far as the date when the third disclosure was given. Thank you.
Thank you very much for your arguments, counsel. We will take it under advisement, and we are adjourned.